Senate will please come to order. Returning from a brief recess, and I believe the senator from Wyndham had the floor for her amendment.
Thank you. I'm actually going to let the senator from Chittenden report on the amendment as she reported on the bill, and it only has my name first because we missed the opportunity to respond in a timely manner to get her name on first. Thank you.
Thank you. The senator from Chittenden, Senator Ron Hinsdale, is recognized.
Thank you, Madam President. Before I address the amendment, I did receive a question during the recess about the nature of support or existing concerns from law enforcement that we heard from as witnesses. I don't want to mischaracterize where they stand on the bill, but I hope many of my colleagues in your Government Operations Committee would agree. When law enforcement came in, they generally spoke to evolving in the direction of many of these provisions anyway, and felt that they were warranted as discussions for 21st century policing. And there were areas of concern that I believe were ironed out in the process. For example, law enforcement in non-custodial interrogations uses false and deceptive methods of trying to access child predators by posing as maybe teenagers or young children. And they were worried that the section on false and deceptive interrogation might interfere with some of those provisions. So instead, we made it a study to look at all of the remaining issues around false and deceptive interrogation, rather than advance, for example, the ban on false and deceptive interrogation for youth. So these were compromises that we made that I truly believe law enforcement saw, appreciated, and we heard no major, what's the word I'm looking for? We heard no major opposition from law enforcement at the time of passage. And if somebody wants to state differently, they may, but that would be my characterization of where we landed on a very comprehensive bill around 21st century policing tactics and models. I think furthermore, one might say that the section on the Giglio database is confidential, except as it relates to prosecutors, and that was important to law enforcement and is aligned with what should be current practice and law. Finally, Madam President, let me address the amendment before you, which is a very small amendment, but one that ensures that there is no fiscal note or cost to this legislation. As we looked at the Section 4 around false and deceptive interrogation, we didn't have time to take on the breadth of issues related to that particular provision. And so we created a study, and somewhat in our haste, we wanted to have all of those organizations named, work together to name an organization to work on the study. And instead, this amendment striking out the selection of an organization simply now requires that we receive a written report from those collaborative organizations on false and deceptive interrogation tactics as outlined in the bill, so that this should not require any additional appropriation. And that is the amendment. We did change the title as well to be more reflective of what ultimately was passed in the legislation, which is around data collection and interrogation practices. Thank you, Madam President.
The question is, shall the Senate amend the report of the Committee on Government Operations as recommended by the senator from Chittenden? And are you ready for the question? The senator from Chittenden is recognized.
I wonder if I might inquire of the reporter of the bill.
Okay.
I wonder if, Madam President, if the committee took testimony or at least considered the burden of reporting in relative comparison to other institutions. As one might know or have heard, I work at the University of Vermont, and we have a great deal of reporting obligations for a variety of different topics regarding different incidents that occur on campus. I know other industries also have many financial reportings and regarding hiring practices and so on. When it comes to the actual reporting obligations that this will put onto law enforcement, did the committee consider its relative burden to those other comparable industries?
Madam President, if the senator from Chittenden could be more specific about which provision he's worried about creating an additional burden.
Why don't we remind them what the question is?
Yeah, just to recall, the question that we're at now is with regards to
the amendment.
the specific amendment.
So should I postpone this question until it comes to the full bill?
Okay.
Right after this.
So after we amend the report, then there could be questions regarding the amended report.
My apologies.
Are you ready for the question? And the question is, shall the Senate amend the report of the Committee on Government Operations as recommended by the Senator from Chittenden and others? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've amended the report of the Committee on Government Operations as recommended by the Senator from Chittenden and others. The question now is, shall the Senate amend the bill as recommended by the Committee on Government Operations as amended? Are you ready for the question? And the Senator from Chittenden is recognized.
Again, my apologies, Madam President. So just to frame the question maybe to that the report of the bill, may I inquire of the report of the bill?
Okay.
If I could frame that differently. A phrase that I always say is you can't improve what you do not measure, and what you measure matters, and you can't manage what you don't measure. And so I wonder if the committee has any comparisons to how this reporting is of similar context and burdensome, if at all burdensome, to other practices in other industries.
Your Committee on Government Operations did not necessarily do a full comparison where other demographic information is collected around other incidents or occurrences where there might be violence or crime involved, or misconduct of any kind. We can say with some certainty that Vermont State Police are already starting to publish information around use of force and any resulting impact of that use of force. It is also published on their website. And they spoke to the multitude of law enforcement agencies around the state at the local level, starting to collect and report that information in much the same way so that people can experience one set of data around law enforcement reporting around issues like use of force that may result in injury or death. So the reality being that this was already something in motion because law enforcement, especially our Department of Public Safety, understand that people don't know which law enforcement officer or agency they're interacting with, whether it's local or state. And we need to be able to collect data that speaks to the full experience of all Vermonters. Those we spoke with understood and appreciated the need to move in the direction of creating shared and liberated data that all Vermonters are able to access to better understand their experience and how to address and receive a remedy for their experience.
Thank you, Madam President. I will close by saying I support this bill, and I think data is always useful to help inform and improve how we manage different aspects of society.
The Senator from Caledonia is recognized.
Thank you, Madam President. May I inquire?
You may.
As I listened to the presentation and looked at the bill, it seems like many of these issues, in fact, transcend the jurisdiction of our Judiciary Committee and past legislation that we have passed and put into law. I was just wondering if, in fact, the bill has been reviewed, or does the Judiciary Committee have a position? Oftentimes they would simply say, we're fine with it, you take the bill. But I was just wondering the extent to which that review had occurred. Thank you, Madam President.
Madam President, if I may, I would yield to the Senator from Windham since she chairs our committee and sits on the Senate Judiciary Committee.
Senator from Windham is recognized.
Thank you, Madam President. We did not, this bill was not run by Judiciary. This does not impose any new penalties or crimes. It strictly deals with law enforcement, and law enforcement is the jurisdiction of government operations. So what did come from Judiciary was the amendment, because it was very unclear about the way the report was written, that the Justice Oversight Committee would be making this report, and so that did come from the chair of Judiciary.
Yeah.
Senator from Bennington, the chair of Judiciary.
Madam President, the bill was originally referred to the Committee on Judiciary, and we're fortunate in Judiciary to have the chair of Government Operations as a member of the committee, and she and I had several conversations about this bill, and we decided to, the Senate decided to commit it to the Government Operations Committee. As first introduced, I think there were a lot of things that involved both committees. But as it's come out of the Government Operations Committee, I think it's pretty much government operations issues. But we did have those discussions.
The senator from Caledonia is recognized.
Thank you, Mr. President. I agree with the previous statement that the Senate Judiciary Committee is fortunate to have Chair of Government Operations in its committee. The Judiciary Committee, although, well, I'll say it this way. The Judiciary Committee is unfortunately also occupied by the only criminal defense attorney in the building. And I'm looking at this language now and I'm beginning to wonder about some things that cause me some concern, although I support the concept in toto. So I wonder if I might inquire the presenter of the bill.
You may.
Madam President, I'm looking at section 2, starting with D2, database. Now, I just want to be clear on this. The database that we are creating here is designed to go to the council, am I correct?
Madam President, the database is designed to be maintained by the council in concert with the requirements of prosecutors to make new entries into such a database.
As I understand subsection E, database is to be utilized by the council in the furtherance of its duties. Is that correct, Madam President?
That is correct, Madam President.
So when I look back at subsection B2, I see the words any past or pending criminal charge. Madam President, can you tell me why the word charge appears as opposed to a conviction?
Madam President, the section in its entirety deals with the credibility of a law enforcement officer in taking the witness stand. When that credibility is in question, my understanding is that an entry is made into a Brady file, not necessarily only when there is a subsequent charge. For law enforcement, there is a higher standard around representing information and a report in a way that is truthful and accurate. And it is the discretion, in my understanding, and I can clarify for third reading, that is the discretion of a prosecutor or the state's attorney when they look at the totality of the information, not necessarily waiting for another jurisdiction to have charged an officer in being untruthful or in engaging in misconduct.
Well, Madam President, I've cross-examined quite a few police officers in my 38 years. And Madam President, I can assure you that a judge would never allow me to ask an officer if he has ever had an allegation against him that has not come out proven. In the issuance of a filio letter, a prosecutor has made a determination that in fact there is a good cause finding that the officer has in fact jeopardized their own reputation for truth and veracity. So I'm somewhat concerned about the word charge as opposed to a conviction, because it is creating a database that is implying based on allegations. I'll get to the immediate question. Did law enforcement have any issue with a database being collected that involved mere allegation as opposed to either a prosecutor's filio letter being issued or a specific finding by a court or a conviction of an officer? Did law enforcement have any issue with that possibility?
Madam President, I would say that all witnesses in this section agreed that this kind of language falls from the decision in the Giglio Supreme Court case, and so did not have concerns about any specific line or provision within this section. Their overarching concern was that it remained somewhat confidential and only discoverable by those involved in a criminal matter where the law enforcement officer may be asked to take the witness stand. So those were the major concerns we heard were around who can access this information not necessarily each subsection or line item, because much of that language falls from a settled Supreme Court case.
Appreciate that, Madam President. And I'm going to look through a couple of other sections here just on the fly. Subsection B3 brings up an allegation of misconduct. And if I read this correctly, it would be an allegation subject to a pending investigation that would now be entering into the database for the council to do with what it normally does for council operations. Is that the way I'm reading this?
Madam President, the prosecutor has an obligation to collect and maintain all information or evidence that could be discoverable by the defense and ensure that that obligation is met. When it comes to the Criminal Justice Council, that obligation is far more about a investigation into past misconduct or overarching concerns into the policies and practices around a particular department or a particular officer. So by the time the Criminal Justice Council might be pulling or reviewing that specific information around an officer, would be looking at the totality of any concerns around any of these sections. So their overall ability to take the witness stand in a credible way, their overall number of counts of having misclassified information. But otherwise, it is the state's attorneys and the prosecution that are required to maintain information relative to a case in a way that's discoverable by the defense.
Well, Madam President, I'd like to play this out for a moment. If an allegation is made by an individual in the city of Burlington that an officer did X, and then the information or allegation is presented to the chief of police, is it the committee's understanding that the chief has a mandatory requirement to report that now to the counsel or the prosecutor?
Madam President, I can consult with our legislative counsel and others to ensure that I'm answering this question accurately, but my understanding is that when there is a concern about the misclassification or misrepresentation of information by a law enforcement officer, that complaint should be lodged. And then if the chief of police believes that there is credibility to that allegation, my understanding is it should end up in their Brady file.
Are you requesting a brief recess, or would you like to respond during third reading?
If the member is unsatisfied with my most recent answer, then I would request a brief recess, but I leave that up to the senator.
There will be plenty of time, I'm sure, Madam President, not to delay the discussion and allow questions to be investigated for third reading, but I would like just a couple of more questions. As I understand it, in subsection B5, it also talks about a pending misconduct allegation. And then it goes on to say any allegation that might have a significant bearing on the admissibility of prosecution evidence. I am unclear as to what exactly that means. Who makes the call about whether an allegation may have some kind of significance to bring it to the attention of the prosecutor?
Madam President, I would request a brief recess to make sure I can put all of these